This is State's Exhibit 75, an email dated October 26, 1998, from Mark Jensen to Kelly Greenman, 11:39 a.m. Ms. Jensen, in this email, does Mr. Jensen forward you the Patagonia.com products link and says, okay, I'll help you out, recognize it here? Is that correct?
Yes.
And then did you reply, okay, I don't see the exact one, but it's similar to the description of the shelled Capilene 2 jacket. It was purple, I think, $119, to right of the entrance walkway, and behind it were the longer jackets with the tie around the middle. I'm not good at asking for things because I'm used to just getting them myself or going without. Too many strings seem to be attached when I let someone else buy. Is that your reply?
Yes.
And then Mr. Jensen replies to that, understand, I know, but hey, I'm having fun, no strings. Well, maybe just one for whoever, and that would only be being, quote, there, close quote. Think I could warm you up. Remember I said I'd give you anything? If you can't try to spoil your GF a little, what the hell, IDLY. Was that his response?
Yes.
And by GF, he means girlfriend?
Yes.
And then you reply, well, the GF appreciates it, trust me, just not used to it at all. Thank you. IDLY, IWY? Was that your reply?
Yes.
And then Mr. Jensen replies, XO, it's fun. There's so much there, I'm really surprised that no one really ever took a real big shine to you and decided you were worth it. Obviously not getting past other thing and checking out the eyes. Is that his response to you?
Yes.
State's Exhibit 76. Monday, October, it begins with an exchange Monday, October 19th, and ends with an exchange of October 26, 1998. Ms. Jensen, did Mr. Jensen in this email written Sunday, October 25th, 1998 at 5:02 p.m. write, oh, I take that back. Let me start below that. Mr. Jensen wrote an email to you sent October 19th, 1998, 4:01 p.m. where the subject was he called. And he writes, BC, question mark, just a thought. Did you smile? Was that his email to you?
Yes.
And by BC, is he referring to Big Cedar?
I believe so, yes.
And what is Big Cedar?
It's a lodge resort in Missouri.
And is he suggesting perhaps you could plan a trip to Big Cedar?
Perhaps, yes.
And then he answers that email to you with another email dated Sunday, October 25th, 1998 at 5:02 p.m. saying, so what do you think? Was that his email to you on Sunday, October 25th?
Yes.
And is he asking you what you think about going to Big Cedar?
Yes.
And you reply, thinking about it, IDLY. Is that correct?
Yes.
And your response is Monday, October 26th, the day after Mr. Jensen sends his email to you?
Yes.
And then Mr. Jensen replies on Monday, October 26th, let me know. I'll see if I can get the HM cabin again, IWY. Was that his reply?
Yes.
And is the HM cabin the honeymoon cabin?
I believe so. I'm not sure.
Had you been to Big Cedar with Mr. Jensen at this time?
No.
Do you know why he's saying, I'll see if I can get the HM cabin again?
No.
Was it your understanding that he had been there before?
Yes.
And that he had gone with his wife, Julie Jensen?
I don't know if he went with his wife, Julie. I just knew he'd been there before. I can't remember the dates.
At some point after Mrs. Jensen died, did you go to Big Cedar with Mr. Jensen?
About a year, maybe 2, yes.
And did you stay in the honeymoon cabin?
Objection to the relevance. Sustained.
And then you reply, what days are you thinking about? Is that correct?
Yes.
And then Mr. Jensen replies, what days are you free? Was that his response?
Yes.
And then you reply that same day, never free, and free is in bold. Is that your reply?
Yes.
And then Mr. Jensen replies later that same day, was waiting for that. Well, what do you cost? See, this is the flip side to that one, and I wasn't going there. Okay, what days are you available? Was that his response?
Yes.
And then you reply, the opportunity was there, so I took it. Smiley face. Would a one-nighter work? Say Friday, come back Saturday, or would that be a problem? That's your reply?
Yes.
And so you are planning with him a trip to Big Cedar, possibly on a Friday, coming back Saturday?
Yes.
And then Mr. Jensen replies that same day, that would work, would only be a problem because of the lack of time, both with this and would need to be fitting a fishing trip in there. Guess I'd be driving. Drive down Friday, fish Saturday, return Sunday. Tough to fish in the dark. That's his response?
Yes.
And then you reply, who are you going fishing with?
Yes.
And is this part of your banter, the who you going fishing with?
Yes, I suppose so.
States Exhibit 77, an email dated October 26, 1998. This is an email from Mr. Jensen to you sent Monday, October 26, 1998, where the subject is mail. And Mr. Jensen writes, so do you get things in the mail that are addressed to Greeman? Was that his email to you?
Yes.
And you reply that same day, yes, it's very weird, but getting used to it. Was that your reply?
Yes.
And then he replies, does Labonte still work? I'll change the name. Was that his reply?
Yes.
And then did you reply for what? Mail, yes. Email, no. Anything else? Is that your reply?
Yes.
And then he replies, nope. And you reply, okay, or K. Is that correct?
Yes.
So in this email is Mr. Jensen expressing a question as to whether your last name has changed for purposes of work?
I guess so, yes.
States Exhibit 78. It's an email dated October 27th, 1998. This is an email from you, Ms. Jensen, at the time named Kelly Greenman, to Mark Jensen. Busy today, voice is better, finally getting the details taken care of for Blueprint and BM meeting. You seem pretty busy today, didn't check your emails until after 11. Busy? Question mark. How was your evening? Saw you were up past 1. My evening was okay, but this morning was interesting. Need to talk to you about it. Was that your email to him?
Yes.
What's the BM meeting?
Branch manager meeting?
Did that occur at the same time as the Blueprint?
I believe so.
And And then you asked Mr. Jensen about his evening. Can you tell us how you would know he was up past 1?
The only way I would know was I received an email that had that time on it.
And by 1, you're referring to 1 a.m.?
Yes.
States Exhibit 72. Begins with an exchange Monday, October 26, 1998. Ms. Jensen, this is an email. Is this an email you sent to Mr. Jensen where the subject is the Patagonia online store?
Yes.
And then there are some items listed below: home, business and economy, companies, office supplies and services, writing instruments, fine pens. Is that correct?
Yes.
And it goes on to list companies that presumably sell pens.
Yeah, that's what it looks like. Yes.
And do you see this one right here?
Yes.
Can you read that, please?
Fountain Pen Hospital.
And is that a company that sells, according to this description, a large selection of contemporary writing instruments, limited edition pens, and vintage fountain pens?
Objection to this witness's knowledge. Here's the answer.
Well, according to that description, yes.
Did Mr. Jensen seem to have an interest at that time in pens or fine writing instruments?
Yes.
And then Mr. Jensen replies to your email that same day. Understand, I know, but hey, I'm having fun, no strings. And that this is a repeat of that prior email where he says, if you can try to spoil your GF a little, what the hell, IDLY? Does it appear to be the same as that prior email we read?
Yes.
But then at the top, the string continues. I'll show you. Here, where you reply, so what is it that you see in my eyes, Mr. Jensen? And then you ask him, do you have a Harry and David catalog? Is that correct?
Yes.
And then Mr. Jensen replies that same day, the eyes a lot, I'm always checking them out, aren't I? Believe I look right in them and see all kinds of things I like. Sweet, remember I told you you were sweet? Didn't believe me, huh? Harry and David, what if I told you I did? And then you reply, okay, don't get excited. I need a copy because I think the family's gifts are coming from there this year. If I find stuff I like I did last year, that's all. That's your reply to him?
Yes.
And then Mr. Jensen replies, I'll see if I can find it. Red meat and fruit. Huh, IDLY. Was that his response?
Yes.
And then you reply, you are so strange sometimes. Actually, I like their plants and some of their gift packages. Not a big fruit fan most of the time. IDLY, chew always. That's your response?
Yes.
And then he replies, I'm strange, huh? They used to be all red meat and fruit, and they can both be fun. I am wine. Is that his response?
Yes.
And then you reply, I am why too. Don't remember the meat last year. Correct?
Yes.
States Exhibit 79 begins or contains an email dated Tuesday, October 27th, 1998, from Mark Jensen to you, Kelly Greenman, at that time. Subject is good morning. Family, or at least David. Yep, real good is great. There's no real perfect, and real good can, underline can be real easy, or at least that's what I remember. Was that his email to you?
Yes.
And you reply, have you talked to her about it yet? Or are you just going to bang her over the head, drag her out to the car, and tell her she's going to have a good time? Remember the caveman days? Is that correct?
Yes.
And in that email, do you know who you are referring to?
I believe I'm referring to Julie.
Julie Jensen?
Yes.
And then States Exhibit 81. Tuesday, October 27th, 1998. Subject is my story. And is this an email from you to Mr. Jensen?
Yes.
And did you write, he said he was up all night frustrated and mad because I have shut myself off from him these last 3 or so weeks. He asked me if there was someone else, if I still wanted to be married, and what was going on with me. At 5:30 a.m. in half a voice, I was hardly in any shape to battle with him, but I did realize I need to give this a fair shot or get the hell out. I've decided to give it a fair shot first, a 6-year relationship that I have fought tooth and nail for, and a 1-month marriage deserves at least one bold effort. Anyway, I would very much like your support on this. Your friendship means so much to me. Parent, maybe too much for the sake of my marriage, close parent. Obviously, BC is out for now. Maybe someday when the cards are working for us, we can do that together. 1, I don't feel right about going right now, and 2, I have a lot to do, and those few days to myself would be a great help. I know things have been funky, but he did notice that I've been funky too and suspected one of the issues. For my own peace of mind, I need to focus on the positives of this marriage and see what happens. So let me know your thoughts on this, please. IDLY, always really, exclamation points, correct?
Yes.
And in this email, are you informing Mr. Jensen that you'd like to give your 1-month marriage more of a chance than you had given it previously?
Yes.
And you refer to it as a 6-year relationship that you fought tooth and nail for, is that correct?
Yes.
And was Mr. Greenman married at the time that you were seeing him or dating him before you got married?
Yes.
No, I was estate. Disregard the answer, folks, please. It doesn't have anything to do with anything of importance to this case.
And although you're indicating you'd like to give your marriage a shot, you still continue to inform Mr. Jensen that maybe when the cards are working for us, we can do that together, referring to a trip together?
Yes.
And when you say that he did notice that I've been funky too and suspected one of the issues, did Mr. Greenman suspect that you were having an affair?
I would assume so. I don't recall the discussion my husband and I had that night.
Pardon me?
I don't recall exactly what the discussion was between my husband and I that night.
Okay. And although you want to give your marriage a chance, you're still telling Mr. Jensen that you still do love him always, really?
Yes.
And then he replies that same day, hey, fair enough. You never did say, quote, now, close quote. My support, you've always got that, Kelly. Only concern I have is for the funky and you being okay, but not going there now. Whatever happens, I really hope that you're that happy little camper. IDLY always. That's his response?
Yes.
And he's indicating to you that he still loves you despite the fact that you want to give your 1-month marriage a shot?
Yes.
And then you reply that same day, as long as I have your friendship and support, I'll be fine, because I know if the funky gets out of hand, you'll be there for me, question mark. I hope we can still enjoy our fun emails and talks. Just need to bring it down a notch, if you know what I mean. Wanted to comment on something you said yesterday about my eyes. It's a control thing for me. I feel myself enjoying myself with you and being happy, and then I start falling, realize it, catch myself, and pull back. It's a protection thing, only in the sense that the timing for falling isn't quite right, if you get my drift. Happy little camper, cute phrase. That's your response?
Yes.
And by just need to bring it down a notch, if you know what I mean, are you referring to your sexual contacts?
Yes.
But you still hope to continue having contact with Mr. Jensen by phone and email?
Yes.
And perhaps in person as well?
Yes.
And you tell Mr. Jensen in this email that you, when you're with him or think about him, you feel yourself falling in love with him?
Yes.
And then you also tell him that if the funky gets out of hand, you'll be there for me. Does that mean if things with your marriage get worse, that you'll know he'll be there for you?
Yes.
And that he'd be willing to have a relationship with you?
I think I meant it as just somebody to talk to.
And then Mr. Jensen replies, wow, you've always got the friends and support thing. I'll be there one way or another. See, a Dear John letter of sorts. Just kidding. We can bring it down a notch. Have wondered at times over the last month what was going to happen with your situation. Just last night mentioned quitting Stiefel before doing anything. Things were really funky. Things were real funky. It was either going to hit the wall or there was going to be a decision to regroup, so to speak, and see if it was going to work. Makes sense. Like I said a while back, I could see how this was going to play out, Denver, etc. Wouldn't it be ironic if the bottom doesn't fall out of the box and the women nosedives, or the bottom does and the women get fixed? Or just think of all the permutations and understand the I thing, if the falling is what I think it is. That's his reply to you?
Yes.
And what does he mean when he talks about Denver, etc.?
My previous husband for business had gone out to Denver to look at opening an office there for that company.
For what company?
The company that he worked for.
Not Stiefel Nicholas?
No.
Okay. So he's referring to the fact that there was talk that you might be moving to Denver?
Correct.
And then you reply, I'm sure the falling is what you think. We always seem to be on the same page when it's us involved. Have faith, Mark. It'll all come together eventually. What's the wow for? Was that your response?
Yes.
And by it'll all come together eventually, are you referring to your relationship with Mr. Jensen?
I think just that everything would work out, regardless of who it was with or whatever.
And then Mr. Jensen replies, yep, I think we're on the same page with the eyes. I'm a little confused. What will come together eventually? Quote, this, close quote, or what, wherever the pieces happen to fall. The wow was for, quote, I hope we can still enjoy our fun emails and talks, close quote. You just seem to be questioning the friends part. That was his response to you?
Yes.
And so in this email, Mr. Jensen is questioning you about what will come together, and he seems to be referring to your relationship with him. By the
Either that or whatever happens, yeah.
Jensen, I'm going to show you State's Exhibit 70 again. And in this email, you tell Mr. Jensen on October 26th, which is actually the day before the email we just read where you want to give your marriage a chance. You tell Mr. Jensen, I think it would be a piece of cake and joy taking on all three of you. Is that correct?
Yeah.
And at the time that you wrote this email, did you know that David and Douglas had a stay-at-home mother?
Yes.
And what would make you or Mr. Jensen think that in the event of a divorce or in the event that you two could get together, that Mrs. Jensen would not have custody of her children?
I didn't think about it. I just made the comment.
You made the comment.
I mean, I figured if they got divorced and I was with Mark, we'd have the boys some of the time.
Now, Mrs. Jensen, although you wrote that email to Mr. Jensen on October 27th saying you needed to give your marriage a shot, did you continue to have contact with Mr. Jensen?
Yes.
By phone and by email?
Yes.
And did you also see him in person?
Yes.
And did you continue talking to him daily?
Yes.
And continue to email him daily?
Yes.
Did you also see him at the Blueprint Conference in St. Louis?
Yes.
And did you flirt with him, and did he flirt with you at that conference?
Objection, compound question.
Sustained.
Did he flirt with you at that conference?
Yes.
And did you flirt with him at that conference?
Yes.
And did you attend the dinner that night for all the brokers who
What night?
attended? Excuse me?
What night?
Did you attend a dinner at the Blueprint Conference that Mr. Jensen also attended?
Yes.
And what kind of dinner was that?
It was a dinner with all the salespeople for the brokerage firm.
Do you recall who you sat with?
No.
Do you recall how many drinks you had that night?
No.
And after dinner, did you go to the bar in the lobby of the hotel?
Yes.
And how long did you stay in the bar at in the lobby of the hotel?
I'm not sure. I was probably there a few hours.
At the time that you left, was Mr. Jensen still in the lobby of the hotel?
Yes.
And was Mr. Klug still in the lobby of the hotel?
Yes.
And were you and Mr. Jensen flirting while you were in the bar at the hotel?
Yes.
Were you telling Mr. Jensen that evening that you still loved him?
I don't recall. I don't think so. My husband was there.
Your husband was there, but you were still flirting with Mr. Jensen?
Objection, leaving argument.
Oral.
Yes.
Did Mr. Jensen call you on the day that Mrs. Jensen died?
Yes.
So the very same day that his wife died, he called you, and did he tell you now his issue was taken care of?
No.
Objection, compound question.
Well, no, the first part was just repeating what she had said in her prior
And
answer.
I don't think it's proper to repeat the.
Well, that part is true, but it's done now, so there was an answer. I didn't hear what it was.
No.
No. Did Mr. Jensen call you also the day after his wife died?
I don't believe so.
Did you have multiple contacts during the month of December of 1998 after his wife died?
Yes.
And did he actually fly to St. Louis approximately a week and a half after his wife died?
I don't recall that, no.
Do you recall him attending a Stiefel Nicholas Christmas party in St. Louis?
No.
And during your conversations with Mr. Jensen in December of 1998, did you begin making plans to leave your husband?
No.
Well, did you leave your husband on January 8th?
Yes.
Object to the well. I mean, it's commenting.
I'm sorry, what was your answer?
Yes, I did leave him in January.
So did you begin making plans to leave your husband in December of 1998?
No, my leave was an impulse leave.
I'm sorry, I didn't hear the answer.
My leave was an impulse leave.
Had you discussed leaving your husband with Mr. Jensen during the month of December 1998?
I don't believe so specifically, no.
Did he ask you to leave your husband?
No.
After you left your husband on or about January 8th, 1999,
Did she object? No.
I don't recall January 8th. Did she say that?
I can
That's what you
ask
said.
it.
Okay.
Okay, I'm sorry. Did you move to Wisconsin?
I didn't move to Wisconsin until end of March, beginning of April.
Did you open a P.O. box in Pleasant Prairie in February of 1999?
I believe I did, yes.
And was that so that you could receive mail in the state of Wisconsin?
I was planning on moving at that point, yes.
So you opened up the P.O. box a month before you moved?
Yes.
And did you come to the Jensen home in December of 1998?
No.
Did you come to the Jensen home in January of 1999?
Yes.
And how often did you come to the Jensen home in January of 1999?
I don't remember. I think I was there a couple of times.
And did you spend the night?
Yes.
And did you engage in sexual relations with Mr. Jensen?
I don't remember, possibly.
Do you recall testifying at the at the prior evidentiary hearing that you had engaged in sexual relations during those visits in January of 1999?
Okay, yes.
So did you?
Yes, then I did.
And did you engage in those sexual relations with Mr. Jensen in the bedroom where Mrs. Jensen died?
Objection. Argumentative. It's not, and she doesn't know.
Sustained.
Well, Mrs. Jensen, where did your sexual relations with Mr. Jensen take place?
In his bedroom.
And this is the same bedroom where Mrs. Jensen died?
Sustained objection.
Okay. Did Mr. Jensen give you $12,000 in March of 1999?
Yes.
And he helped you move from St. Louis to Wisconsin?
Yes.
Was your divorce finalized in March of 1999?
Yes.
At the time that you were married to Mr. Grieman in October and November of 1998, did he drive a Volvo S70?
Yes.
Did you live in an apartment after you moved to Wisconsin in March of 1999?
Yes.
Did you spend multiple evenings at the Jensen home?
I was there late, but I don't think I ever stayed the night after I moved up here.
Were you present at a birthday party for David Jensen in January of 1999?
Yes, I was.
Did that party take place at the Jensen home?
Yes.
And do you recall who was present at that party?
Mark, the children, a lot of their guests, Paul and Jill Griffin.
Were Florence and Dan Jensen present?
I don't believe so.
Were Lori and Todd Coster?
No,
Who were the other guests then besides,
just the children is all I remember.
and Paul and Jill Griffin?
Yes.
And did Mr. Jensen introduce you to his children and to, well, did Mr. Jensen introduce you to his children as a friend?
Yes.
And did Mr. Jensen introduce you to Paul and Jill Griffin as a friend?
I believe so.
So he did not tell Paul and Jill Griffin that in fact you were his girlfriend?
No.
So he lied to them?
Objection, that's not a lie.
Sustained.
He was misleading to them?
Objection.
Sustained.
In December of 1999, the one-year anniversary of Julie Jensen's death, did Mr. Jensen give you a $3,000 diamond bracelet?
I don't know.
Did he?
I received a diamond bracelet. I'm not sure when I received it.
Are you aware that he purchased that diamond bracelet in late November, very early December?
No.
And in December of 1999, the one-year anniversary of Mrs. Jensen's death, did you and Mr. Jensen move in together into a new house?
On what date?
In December of 1999.
Is there
A specific date, or is it just the month?
Is she going to ask it in the form in which she's got it posed?
But I think she initially asked a particular date, and then she backed it up to the particular month, and I don't think it's clear right now.
Which is your question?
I said in December of 1999 for the one-year anniversary of Mrs. Jensen's death.
Well, I suppose that makes the question vague, so why don't you rephrase
I
it?
can rephrase it. Did you move out of your apartment November 30th of 1999?
No, I moved out before the end of my lease, I believe was November 30th, or that's what I paid the rent through. But I moved out before then.
And did you and Mr. Jensen begin moving into a new house December 1st, December 2nd, and December 3rd of 1999?
No, he moved into it in September.
But you moved into it in December.
objection? She said
November.
No.
She said, he moved- when did you move into the residence, if you did?
I believe I moved in before Thanksgiving.
And this was a house other than the house on Lakeshore Drive where Mr. Jensen and Mrs. Julie Jensen had resided?
Yes,
And was it a bigger, more expensive house than the house on Lakeshore Drive?
it was bigger, but it was barely more expensive.
Well, do you recall that it cost $30,000 more than the sale price of the home on Lakeshore Drive?
Approximately, yes.
And in the process of moving into that house, did you and Mr. Jensen or Mr. Jensen spend approximately $18,000 in furniture?
objection to the relevance.
What is the relevance of that?
The relevance is the financial motive.
Well, the acquisition of the proceeds of the insurance policy, the manner in which they're utilized is irrelevant. So I'm going to sustain the objection.
And there were proceeds, we already had.
That is true, that as of this time, there have not been proceeds paid.
I would like to say a little bit more about that.
Go on to something else, we'll come.
Okay.
If there's, at the break, we'll take it up.
Okay. Mrs. Jensen, do you know what the IDLY bar is?
The what?
IDLY bar. Was there a bar that you and Mr. Jensen would meet at that you referred to as the IDLY bar?
No, I'm not familiar, no.
What grade is Douglas currently in?
7th grade?
7th grade. He attends Kenosha Public Schools.
Yes.
Did you recently have to apply for a reduced price lunch for Douglas?
Yes.
And is that an income-based formula?
Yes.
And you were granted reduced price lunch?
Apparently. I was never notified.
Well,
My children told me, yes.
in the course of your relationship with Mr. Jensen, did you come to know Dan Jensen?
Yes.
And is Dan Jensen Mark Jensen's father?
Yes.
And did you come to find out that from your husband, Mr. Jensen, that Julie Jensen and Dan Jensen did not get along?
Object to the relevance.
Overruled.
Yes.
And was that because Mr. Jensen is sexist and holds a low, Mr. Dan Jensen is sexist and holds a low regard for women?
Objection.
Your Honor, I'd like to be heard on that issue outside the presence of the jury.
We'll take it up later.
So would I.
Your Honor, I don't have any further questions at this time, but I think there's some issues we need to take up before I officially conclude.
Let's take a break. Please don't talk about the case during the break.
Please all rise.
Well, starting with the purchases, that issue.
Right.
I think that they're relevant because it demonstrates a pattern of living by Mr. Jensen in which he's very materialistic and indulges in very expensive items. And as such, he would have a financial motive, one, to get the insurance money, two, to not want to split his money with his homemaker wife who didn't earn any money during most of the course of their relationship. So that's why I was beginning to ask those questions.
But you know, there are people who are very, who are skinflints, who spend as little as possible, who are just as avaricious as people who spend themselves into bankruptcy. I don't see the point.
Well, we're arguing to the jury that there's a financial component.
But you see, that can be established without regard to the spending habits. I mean, there are people. Look at Michael. Oh, I can't think of it. The biggest stock fraud in history. What was it? What?
Milliken.
Yeah, went to prison for this man had hundreds of millions of dollars and was still trying to steal money from people. More than he could ever spend, and he's still trying to steal. So I don't think the quality of being avaricious is demonstrably linked to people's spending habits. So I'm not inclined to allow that testimony or argument for that matter.
Ms. Gabrielle apparently didn't know this, but during the course of Michael Milliken's trial, they presented evidence of the lavish parties that he would, like the $1 million birthday party that he threw for his wife. And the reason they...
Object to any $1 million birthday parties being put into evidence.
I understand it, but in Mr. Milliken's case, it was relevant and it was admissible. And the fact is that spending habits can be relevant. Now, you offered up the example of a skinflint, and if a skinflint was on trial and we could present evidence that he was very, very concerned about money, that could be another motive for somebody to commit murder. And
Look, trial's long enough without getting into spending habits. You're talking about he spent the money that he didn't even have. I mean, what does that say? It doesn't tell me, it doesn't tell the jury anything.
We're not talking about the insurance proceeds, Your Honor. We're talking about an estate of worth maybe $500,000.
Okay.
And you get $500,000 of it instead of $250,000.
If you want to prove the value of the estate, that maybe I'd look at that differently. But whether they spend the money on furniture or spend it on jewelry or spend it on gourmet foods, I don't see where it makes any difference to the jury. And as I say, the trial's long enough already, so the answer is no.
And Judge, just to register my objections on it, it would be 404B evidence for which I didn't get notice, and also, I mean, I think it's a far cry to find somebody materialistic based on some purchases at some point in their life. I mean, there's all sorts of reasons why at some point people buy things. We just get into it.
All right, the objection is sustained.
Just for the record, he did get notice because he got copies of all of Mr. Jensen's financial documents, which is where we found all his check writing activity.
All right, I've sustained the objection.
The
What's
next subject was regarding Mr. Dan Jensen. Mr. Dan Jensen has been a source of information for the defense expert who came up with a conclusion based on, in part, Mr. Dan Jensen's assessment of Julie Jensen's character and personality and behavior, that Julie Jensen was in a major depressive disorder and was suicidal at the time of her death. I think the fact that he has a bias against Mrs. Jensen, and in fact has a bias against the current Ms. Jensen due to his sexist viewpoints, is pertinent to how much weight Mr. Dan Jensen's viewpoints should be given.
We are not going to have this trial about whether someone who's not even on trial here is a sexist individual or not.
Well, can I ask her if they got along?
Yes?
Well, but I don't, what's the relevance of whether Kelly Jensen and Dan Jensen get along in 2007 and 2008 when his son's in prison and all sorts? I mean, it doesn't have any relevance to anything. And I have a strong...
Really get along? Mm-hmm. You mean in an effort to show that she's having trouble with him as well? Is that it?
That's it.
No.
And that he's not an accurate source of information when it comes to his daughter-in-laws.
You know, if he wants to bring in a bunch of other women who say that he gets along very well with them and he's very cordial in his relationships with women, and shall I entertain that evidence too? This will take forever. No.
All right.
And Judge, I have strong objection to it. I believe the last question that was objected to and sustained is, she said something like, it's true, or isn't Dan Jensen sexist, or something like that.
She said something to that effect.
Yeah, and to engage in that kind of name calling against somebody it would not be admissible character evidence.
I have to say that I was very, very disappointed that you would fire off a question like that in court. You ought to have known that would cause problems. So that's what I want to say. All right.
One more.
Yeah, go ahead.
The CDs of the phone calls.
Okay, well, I have one actually. Now, I just want to make sure that we don't get into a squabble later in the trial. There are more emails. Are there not?
I believe there's one more email dated December 2nd.
Ooh, are they coming into evidence?
I'm not introducing them.
Just so I know, you're not going to recall one of these witnesses to the stand to introduce that material?
No, I feel that email contains a lot of self-serving statements on the part of the defendant.
Well, I'm not advising you as to how you want to proceed, but I just wondered if we were going to see that in evidence, and if so, through what vehicle? And if you're telling me that you don't intend to offer it, fine. Now, what was the one more thing?
Your Honor, these CDs, I provided them to defense counsel last night, and as directed by the court, and I didn't get them back until just before court started. So when I listened to them last night on the CD that I have in my room, it doesn't have a counter on it. So I don't know exactly where these statements are on the CD, and I think that we need to put them on this recorder, which is something we would have done this morning, but we didn't get them back in time. So now we need to do it now. So we need a long enough break for me to find...
You know, why wasn't this done before the trial? I don't understand this.
Well, Your Honor, we had fully expected that Mrs. Jensen would not be testifying that this conversation had occurred at the time that she says it now occurred. But it was...
Well, you told me yesterday that you were suspicious of that very thing.
Well, we'd heard the defendant make those kind of statements, we have a number of CDs where this defendant is trying to coach people as to what they're going to say, but we have no reason to believe the witnesses are going to be coached in that fashion. Now, in this particular instance, we had this CD where the defendant was telling Kelly Jensen at that time that, that conversation didn't occur in 1998. We had not expected that she was going to be testifying in that manner because we have clear evidence that these documents were created by the defendant in 1998.
Now, copyright from 1997?
Yes.
Well,
Your Honor,
It's not nearly. It wasn't nearly as clear to me as it was to you.
well, Your Honor, I would ask you this: if you've got any daily planners for 2008. You can expect that the copyright is going to be somewhere around 2007. And if you've got any daily planners for
knowledge, no.
Judge, and if I could just interrupt on that point, in the same stack of documents that I received with the planner, here's a page from June 13th of 2000 that has a 1998 copyright date on it. So there goes the wonderful theory upon which that was based, because this is 2 years afterwards. And the pages on which the other notes are written are blank pages, so there'd be reason that the company would publish those even further in advance and not change them. But from that same planner, we have a 98 copyright for a 2000 calendar. The other thing is that these were all seized, the court will recall, in June of 2004. And all these planners, I believe, are from 2000 and later. They're not 1998 planners. And in fact, those were seized from Mr. Jensen at the time of Mrs. Jensen's death. They took his current planner, and it wasn't in that planner. And then this is a later planner that they seized in June 2004. So, I mean, I don't think there's any, and in terms of this coaching, one of the CDs I listened to yesterday, the coaching consists of Mr. Jensen saying something along the lines of, we need to put together a timeline or something like that. That's something that I probably beat Mr. Jensen up about all the time, is because I don't have as much time, especially after he was in jail, to talk with him. I'm like, put together a timeline or something. Give me some information as to what's going on. There's no coaching. There's no here's the timeline and let's get it done. And the conversation that Mr. Jensen has regarding the timing of these notes about Jock Joseph, what he's telling Mrs. Jensen is that I had been arguing in court as to how were these relevant from 2001 and 2002. I don't want to argue about it
at this point because the issue is actually not up right now. How long of a break are you talking about?
20 minutes or so.
Oh, man.
But Your Honor, but wait, I believe that I'm permitted to make an offer of proof concerning the evidence regarding these documents that record this that record Mr. Jensen's notes of his conversation with Kelly Labonte, establishing that conversation occurred in 1998. It's an important point, so I think I should be permitted to make that record. So here we have excerpts.
Can I have copies so that I have them in front of me while we're talking about them?
I believe that Ms. Gabrielle is getting the copies right now. We're looking for them.
Exhibits, the salacious materials.
No, and once you get them and you look at them and you look at the document that we're referring to that has the copyright of 1997, we're going to ask you to look at that document and compare it to this document, which comes out of the 1998 planner of the defendant. And you'll see it's identical at the bottom. It's identical.
I haven't got anything in front of me right now, and I want to see, and I don't know what you're talking about when you say this document.
Okay, so you're going to dig through them here? Well, Ms. Gabrielle is digging through the documents from the salacious remarks. I'll show you this page, which is out of the planner that we obtained from the defendant for 1998. And you can see, Your Honor, the dates on the,
Do you know what he's talking about? The particular document he's given me?
well, we got it from them, Your Honor. We got the defendant's day planner from defense counsel.
But this particular page, do you know what?
Well, he hasn't seen it. I'll show it to him.
All right, so just so we all can talk about the same thing at the same time, or we'll never get anywhere.
This is the page from the planner that you obtained from.
Well, let me just see.
And, there's a number of them, that we have a number of these pages. And, Your Honor, if you look at these pages from this 1998 planner, you'll see that they don't have any dates across the top of them.
Okay.
There are
Well, it's
portions of
handwritten at
the-
the top, Stiffel Nicholas and Company Incorporated, that someone would handwrite that suggests that this was blank and somebody felt, but go ahead.
Now, if you look at that document, and then you compare it to, I think it was the last few pages, I want you to look at the pages in these documents and compare them.
Well, they have page numbers on the bottom. Original dash CO, there's a 17393 and the other one is 17404. Another one is 17392. Presumably those were sequential. But there's two, well, no. I guess they're not, that doesn't show that because there's another one here that has 404 on it.
Yes, and Your Honor, if you look at these, here, there's others here with a phone that, like, for example, a name and address, and if you look on the left-hand side here, it says 1997 Franklin Quest Company printed in USA, and then on the right-hand, on the bottom of the right-hand says original CL 17582. So those numbers can be different in terms of the CL number, and we could bring in, I suppose, somebody from Franklin Covey to explain what that means, but there's clear similarities indicating that this document here is from the 1998 planner of Mark Jensen's calendar. And
Why?
they look exactly the same, Your Honor. They look exactly the same, and they get the same copyright date from 1997. Now, do you suppose that that they printed their 1999 calendar in 1997 as well, and their 2000 calendar in 1997?
Why do you assume it's a day plan?
Because it looks like the day planner in the defendant's calendar, daily calendar from 1998.
I'm going to ask that, because I can't tell what's going on, that he is up there pointing at particular things. We're not making a record on this.
Well, why don't you come up here and you can see what I'm pointing at?
It still wouldn't be clear on the record.
Well, Your Honor, I'm looking at a document where the top writing on it is Barry Peterson, underneath that Dave Naring, underneath that Dan Exner.
No, I don't see that paper.
It's right here. That's what I'm pointing at right
I haven't
here.
got that paper.
But I didn't say you had it. I said that's what I was pointing at, and that's what I was referring to. And I want you to compare this document, which says 1997 Franklin Covey Company printed in USA. And it's
It doesn't look, why do you say it's a date planner as opposed to a notepad?
now, Your Honor, I want you to look at this exhibit.
And they don't look alike because that one doesn't say date on the top and this one does.
That's all right.
And Judge, if I could add some information to the record, Detective Ratsberg seized Mark Jensen's 1998 day planner on December 3rd, 1998. He didn't have any of these notes that are being referred to here. Then those were seized in 2004. I think it's perfectly reasonable that Franklin Covey, if those are additional blank pages, as the court noted, they don't have dates, there's no reason to recreate a new blank page each year. Those would just be somewhere for random notes, not in the calendar. All of these, this whole calendar, including the ones if Mr. Jamboys didn't show, like I just have some notes from June 3rd on a calendar page dated June 13th, 2000. All these things were together. 2000 what's clearly the 2000 day planner, and then those blank pages. But they were seized by Detective Ratsburg 98. None of this stuff was in there. Seized in 2004, it was in there. It's because it was all afterwards. And there's no evidence to the contrary.
Well, I don't know that I share your view of that, but I certainly don't. You talked about bringing someone in from Franklin Covey. Maybe that's the key, because maybe somebody can establish what these are. I don't know that they're, quote, day planners. The fact that they have vertical rules on them, lines,
You mean
almost
horizontal?
suggests to me that they're just like notepads or something like that with a date plan.
You mean horizontal lines, Judge?
No, vertical. They're vertical
See which one you're-
along the sides.
Oh, okay, along the sides.
There are also horizontal lines, but I'm not. I mean, from what kind of a pad did these come from? Is it in fact from a day planner, or is it from a notepad? And the documents are not the same, because some of them have the date indication on the top and vertical, is that the right word, rule? The one Sister said, always right on the right side of that little vertical line.
She didn't say it to me, Judge, so I don't know.
Well, you went to public school, but that's why you, well, anyway. And some of them don't have those. So I don't know.
Okay.
They don't look like they're necessarily from the same source.
Well,
So you're-
we can go to that with something from Franklin Covey, Your Honor, but in terms of what we want to do with this witness after the jury comes back is we want to play those CDs, and so we got to get started on finding the precise point
I
of the
don't
CD.
want this to happen again during this trial.
I apologize, Your Honor. I'll accept full responsibility for it, and we are in the process of duplicating all of the CDs in our possession, and we're turning them all over to the defense.
Well, then we have the Irby problem. You might put red stickers on the ones that you think that you may be using to impeach people.
I mean, for instance, the two CDs at issue here each contain 5 conversations, and each conversation, I think, is about 15 minutes long. So it's 150 minutes of conversation on just these 2 CDs, and they're talking about multiple CDs. I simply can't listen to those and then try to figure out what might be important and then get it transcribed and figure out a way to use it. It's just not possible in the midst
Well,
of
I've
the
stated
trial.
I don't want it to happen again. Of course, if it happens again, then we'll have to take whatever measures are necessary to make sure it doesn't happen again.
And Your Honor, forgive me, I don't know what you mean by an Irby problem. It's
That's the case where the
IRBY.
prosecutor gave the defense attorney a list of 97 witnesses, the vast majority of whom were never going to testify, and the Supreme Court said that's an abuse because the defense is just snowed under. So that's the right case, isn't it, Irby?
Yeah.
And you've got to give them fair notice so they can actually be ready, and that's the same thing here. You can't just dump all kinds of CDs on him. You've got to alert him to ones that you reasonably think you're going to use, and I accept you at your representation that you didn't purposely do what's occurred here, but I am simply telling you better re-examine this so it doesn't happen again.
I will make every effort to ensure that it doesn't happen again.
All
Your
right.
Honor.
So let's reconvene at the earliest possible moment.
We will do that, Your Honor. Can you go through those, and I've got to do something else.
Court of Appeals has made a decision about reporters having to take down things that are played in the courtroom on an audio device. And I'm assuming that it was so that they can review the record effectively, efficiently. But really, when you think about it, what the jury's hearing is what the jury hears, not what the reporter hears. And the acoustics, even in this excellent courtroom, are not such that it's the same as the spoken word, because a lot of what the reporters do, as all of us do, we hear much better when we see the person's lips, even if we don't read lips. And many other considerations. Does anyone object if I tell the reporter that in the event there's a later issue about it, that she may listen to this tape recording or this audio CD at that time and make her transcription of it at that time as opposed to taking it here in the open courtroom with all the sound banging around.
Well, in other words, you'd be instructing her to do something the Court of Appeals has said not to do?
Well, they say, they said that the reporter's supposed to take down what's played on the audio device. But that could be done anytime. It doesn't have to be done right here in this big room where the sound doesn't carry so well.
Well, Your Honor, I'd put it this way. I have a high opinion of my own opinion, but I understand in this courtroom your opinion prevails, and so when there's a disagreement, we do what you say. And if there's a disagreement between you and the Court of Appeals, I'd say we should follow what the Court of Appeals says.
Of course, I will always follow what the Court of Appeals say, even if I don't agree with it. I'm not saying that I wouldn't. I'm asking if parties would waive that.
I don't have an objection, Your Honor, to her. If the Court of Appeals wants her to take this as it's being played in the courtroom, I think she should do that. And again, when it's played in front of the jury, I think she should do that. And then later on, if she has a question about what was actually said, I don't have a problem.
No, I will not tolerate that. She's not going to prepare a third one based upon what she hears outside the courtroom. If the Court of Appeals wants what comes out of this courtroom, that's what they're getting. So the heck with it. Play it.
Okay, thank you, Your Honor.
Take it down.
Okay.
You can argue about it with the Court of Appeals if you think there's an error.
I won't argue with the Court of Appeals, Your Honor. It's the Attorney General's office.
No, I mean, you can argue, I meant you can argue with Mr. Albee about it if there's a content dispute, given the poor conditions in which it would be being played. It makes absolutely, well, I'll say nothing more. Go ahead.
Thank you. This is an excerpt of a conversation between Mr. Jensen and Mrs. Kelly Jensen from September 14th, 2007, in which, prior to the excerpt that you're hearing, Mr. Jensen is referring to what happened in court either that day or the day before regarding some motion hearings. And then he brings up the topic of this note, the John Jock Joseph note, and tells or reminds Ms. Jensen that it was written in 2000 or 2001.
Don't think
What
that
number
thing I
is
can read
the
off
machine
of.
right now?
This is call number 5, and I'm beginning the play at 9 minutes and 26 seconds into the call.
Has this got an exhibit number?
No, not yet.
Well, at least make it Exhibit B at this point, I think. Exhibit B, just at this point.
Why not just sign an exhibit number, Your Honor?
Well, if you want to give it a regular exhibit number, that's fine. Usually those that I'm in question about whether they're going to come into the regular trial, we give a alphabetic number or alphabetic designation, but
I think
I don't care.
just for clear the record, I think we should use that. What's the exhibit number?
This will be State's Exhibit 162.
Thank you.
Whatever you want.
They brought in, but I'm not sure. There's so much crap going on.
It rewound to the beginning of the call. I can't hear you. I said it rewound to the beginning of the call.
Now for the Court of Appeals, write down ringing sound.
I don't think that note that they had you read off of, they brought in, but I'm not sure. There's so much crap going on, but it's kind of funny. Craig says, I don't know how he wants to use a document that was produced in 2001, 2002 as, this produced to show knowledge on somebody's part so that they might be on a computer looking at something pertains to what might have happened 3 years later, 3 years prior to the note being produced. There was just this dumb silence at that point going, okay, well, we hadn't thought of that, so, it's crazy, isn't it?
What note?
Oh, that one with Jock's name on it.
Oh.
I mean, it's, you know, that wasn't a conversation we had in 1998. But yeah, I don't think that's going to... Trying to do is just nullify everybody who doesn't, you know, say something positive for them. They're going to go down the line. They're doing it to Laura. They're doing it to you.
Before I take it out, do you want to hear it again or no?
Why don't we just keep it where it is?
Well, I can't and then play the next.
Just
oh,
put it on
well,
pause.
okay.
We'll rewind if we need to.
Okay.
No, what do you want to say?
We want to play that to the jury, right? It's an indication that the defendant was coaching the witness as to what to say about that conversation.
Judge,
you want to say?
That's not coaching. This whole conversation up to this point, he's telling everything that happened, his opinions about what had happened. I think we had a hearing that day. I think it was September 14th of 2007. I think that's the day we had a hearing. Mr. Jensen is discussing all those things. His wife has virtually no response to anything he has to say. He's just talking. And even in the clip the court just heard, she listens to him and he keeps talking, and finally she's like, "What note?" And he's like, "Oh, you know, that note." And he says, you know, and that was in 1998. There's no coaching going on. He's not like, let's get this straight, that was in 1998. I mean, he's just saying what is obvious, and he's mostly talking about what I had to say in the courtroom based on my review of the documents. I mean, he's not, this whole thing, he's talking about venue issues, he's talking about rulings on other acts, he's talking about being unhappy about the court's rulings on other acts, and he's just rattling off all these things. And as the court has heard, the district attorney has dozens of hours of tapes, and that's the coaching that Mr. Jensen says what he believes this wasn't a conversation in 1998. He's certainly free to talk to people without being coaching. I mean, anything he says, if he says, you know, whatever, remember we took that car ride? Oh, that's coaching automatically?
It could be. Not automatically, but it could be. And ultimately, my job is to let the jury hear every piece of relevant evidence that is not by law to be kept out for a good reason.
Well, the good reason is that I don't think any relevance has been shown. It doesn't sound like coaching. If you listen to the rest of the tape,
I don't know.
It doesn't sound like coaching.
Well, I haven't listened to the rest of the tape.
And then we end up having to argue about this with the jury and spend that time, and it's a waste of time on a point that doesn't very clearly support what the state is saying. I mean, when they have maybe 100 hours, who knows, of Mr. Jensen's phone calls, and they say him just letting her know what happened and saying that didn't happen in 98. How is that coaching? He's not saying get that right for your testimony.
Well, there you're arguing. You're saying that's something for you to say to the jury. Look, he wasn't coaching the jurors, and you can hear it for yourself.
Not everything that they can argue should be admissible as testimony, Judge.
Tell me the rule I should keep it out on.
Let's start with 90403.
No, I don't think you're using that as a catch-all through the trial to keep out everything that you don't like.
No, I am not. Because I would start with 90402. Obviously, the court sees some potential relevance to it, but I mean, how does the fact that anytime the use of these recorded statements, he's not telling her what to say. Doesn't there have to be something where he tells her to say something that's false? He's not telling her, he's not correcting her, he's not telling her to say something false, he's not telling her to change her mind.
I understand what you're saying, and certainly those are more blatant and evident cases of tampering than a more subtle form. But for me to slam the door and say, no, the jury can't hear this, statements of the defendant himself. No one knows more about the situation than he does. And these are his statements. And for me to say to the jury, you can't consider this evidence, you have to give me a very good reason.
Well, I mean, I'll tell you another problem, Judge, because when I get this stack, I'm going to ask for a long continuance when I get this stack of CDs from the district attorney, because in the rule of completeness, I may be required to play hours worth of conversations to show that what he does is he talks about his case and why he's innocent, and he talks and talks and talks about the reasons he's innocent and his view of the facts of the case, but that he is not coaching.
Well, much of those would be hearsay statements under State versus Johnson.
Their completeness, because they're trying, no, because it's the only way the jury can understand that this 10-second snippet is not coaching in the slightest bit. The only way I can show that is to play all of his.
Maybe he's trying to coach all the witnesses.
Maybe, but I can play completeness to make my argument. Again, the same thing the court's saying about it's being relevant because it allows me to make the argument. I don't see any other way. It's being taken out of context to bring this 10-second snippet rather than play whole conversations. The problem with the whole conversation, Mr. Jensen has not too kind things to say about court rulings and about the prosecution's conduct in this case. No surprise the rulings didn't go his way that day, but that's certainly not admissible for the jury. But I would have, I think, the option of playing lots of hours of tape, but I need time to listen to lots of hours because that little snippet we hear is taken out of context. His wife listens to this whole conversation. She has no response to anything. He's not talking to her about what her testimony should be.
May I hear it again, please?
From the same starting point?
Yes.
Your Honor, maybe we should play it a little bit earlier than that, so that, I mean, counsel's making an argument on the doctrine of completeness.
How long is the whole conversation?
Oh, the whole conversation is 15 minutes long.
Make it, run it back 3 or 4 minutes.
2 to 3 more?
Instead of starting at 9:26, it started around 6. You want to do that?
6.
Yeah, it was calling you a liar today.
Oh, yeah?
Yeah, because first you said we hadn't, and then after talking to the attorney, you said we had, and he says, she got her story straight done and all this other crap, so, what he tries to do, if you don't say anything that he wants you to say, he tries to vilify you, ultimately.
Yeah.
And then that's what it is all across the board with everybody in every way, And, I kind of talked to Stephen Craig about that today. I said, he's very effective at telling a story and using not much of anything to back it up. He doesn't have a lot of data points, in his story. And the story keeps changing. When we talk about it, you keep telling me that something, this isn't strong enough, this isn't good enough, I need something more, and stuff like that. Because that's what it comes down to, is evidence, and I said, yeah, but he gets away with it and he sells it. At the end of the day, it's believable. Schroeder buys into it, that's why they said, he's good at the soundbite stuff. It's just, but again, it's been the story, So that's basically it. So we just got to sort out again how to defend this thing. I mean, most of that work was already done years ago when we went through it. I think out of the 16 pages or something, you can identify almost 100 phone calls during the evening when we're home, presumably together, most of the time, if not all the time, and calls come in that she's logging, it can't be me, on and on and on, so. Just that kind of stuff. But, it's going to be, it's like Steve said, it could make measurably longer trial. It could make the trial hold 2 weeks longer. It could push it out to 8 weeks now, 2 months. It's crazy. So that's what happened today. Good and bad, And we'll see what happens in 2 weeks when they get their shit done. Or the end of next week, we should know something about the samples.
Yeah.
We'll even have, it turns out that the DA talked to Dawn well before we did, and they knew about her, even when Ed was up on the stand.
Yeah.
And Dawn told them, no, this didn't happen. There was none of that in the conversation. Well, now Ed's saying apparently that he said that part of the conversation occurred later when we were just, alone together. But come on, I mean, he didn't have that initially. So, it's crazy. So, Craig wouldn't tell me everything on the phone, but there's something else going on with that too, so. He had Morse around and waffles and, ultimately at the end of the day, the DA doesn't have a whole lot, but now they get to make this whole other acts. It's crap. Which I don't understand how this shit comes in, but it's one more thing to have to defend yourself against.
Yeah.
It's just the BS of it, So, all that crap with, I don't think that note that they had you read off of, they brought in, but I'm not sure. There's so much crap going on, but it's kind of funny. Craig says, I don't know how he wants to use a document that was produced in 2001, 2002 as, this produced to show knowledge on somebody's part so that they might be on a computer looking at something pertains to what might have happened 3 years later, 3 years prior to the note being produced. There was just this dumb silence at that point going, okay, well, we hadn't thought of that, so, duh. It's crazy, isn't it?
What note?
Oh, that one with Jock's name on it.
Oh.
I mean, it's, that wasn't a conversation we had in 1998. But yeah, I don't think that's going to... What it's trying to do is just vilify everybody who doesn't, say something positive for them. They're going to go down the line. They're doing it to Laura. They're doing it to you.
Let it go.
I'm so tired of this, sweetie. Bring it on. Go on it over with.
Yep.
I am just...
Well, Your Honor, now that I've heard it a second time, I'd like to start playing it at 6 minutes instead of at 9 minutes and 26 seconds, because I think it's clearer if you put that statement in context. I think it's even more clear what the defendant is trying to accomplish. When we're talking about the admissibility of this statement, let's get back down to the principal rules of evidence. And this is a statement by a party opponent. And is it being offered for a relevant purpose? And yes, it is. And so I think that conversation starting at 6 minutes and going to about where we cut it off is relevant, and it demonstrates consciousness of guilt on the part of the defendant. But even if is it being offered for any relevant purpose? And yeah, it's being offered for the relevant purpose of showing that this witness, this defendant, is tipping off this witness as to what she's supposed to say about when that conversation occurred regarding John, Chuck, Joseph. So we'd like to play the tape starting at 6 minutes instead of at 9 minutes and 26 seconds, as was just played just now to the court.
Did you want to respond?
Judge, the rest of the tape is about, it's about all sorts of things, but I guess he spends a fair amount of time complaining about the other acts kinds of issues that have nothing to do with Kelly. That's obvious. That's obviously has nothing to do with coaching. I mean, there's not one thing in that whole area that he's talking about up to the note in which Kelly is a potential witness or has any relevant information. It all has to deal with things dealing with Mark Jensen and his marriage to Julie and events before that. So I don't see how that comes in. But what it does show for the court is that Mrs. Jensen is just letting her husband vent. He's just venting about what happened in court that day. He's venting about his problems in jail. He's venting, at the end, I'm so sick of this. It's a tough day in court. He's venting this the way anybody might do to their loved one about what happened. And to take any statement he says or any complaint
as being relevant, that's just, one, it's just not right, but it does open up this whole can of worms as to, well, what do we play? And it's out of context unless I play all of his conversations to give this jury an understanding. But of course, we can't play all the conversation because there's no relevance to him talking about what his lawyers have to say. There's no relevance, and it is excludable, I think, under 90403 to have him give his opinions about Mr. Jamboys or about the court or about his lawyers. And those aren't admissible as relevance and prejudice grounds. And also, when we get to the rule of completeness, this does become a whole new area that shouldn't be gone into.
Well, you were talking in the preceding days about improper bolstering. That was one of your objections, and I thought about it, and I thought we have a statutory evidence code in this state, and I wondered, where's that in the statutes? I mean, what I admit and what I don't admit is determined by what the statutes say about what's admissible evidence and what isn't, and that's some amorphous term, improper bolstering. Now that can be a code word for some kind of a statutory deviation from the statutory plan. Now today you're telling me, well, this isn't fair. Well, the code is designed to ensure a fair trial, so you need to have statutory references to what I should and shouldn't keep in instead of just this catch-all 2 and 03. No. This is evidence that the jury can consider, and I don't think it's the judge's role to slam the door on the jury and say you can't consider this evidence.
I disagree. The evidence code doesn't make the court, with all due respect, a potted plant. I mean, the court has to look at what this means in the context of the whole trial and how much time it's going to take, given its minimal relevance and minimal probative value.
If the jury decides he's trying to coach a witness, the probative value is not minimal.
But and if he was doing Aaron Dillard, you got that? You understand? Coaching kind of things, then I would understand, but we don't have that here, and so I honestly think I will need a continuance to listen to phone calls so I can present a full, reasonable picture of what Mark Jensen's phone calls are all about, instead of some short little snippet.
Well, now you have had access to a large array of calls already, have you not?
This is coming in.
I'm not talking about this one. You've had a lot of phone calls. You've heard a lot of these phone calls of your client talking to various people who are witnesses in this case. So this is not, you're making it sound as if there's all kinds of tapes or CDs and that you've never heard any of them. And you apparently have heard of large numbers of them. Now, maybe there's some you haven't heard. I understand that. That apparently is the case. But you have already listened to enough that you can give, if you want to respond to this under the rule of completeness to show this is how he talks to all the witnesses. And as I said, that may end up proving only that he tries to control all the witnesses. I don't know. I don't think there's been a sufficient showing that that's necessarily going to be a problem, that there's necessarily any need for an adjournment. If that happens, then we'll have to deal with that. And I warn the DA that I do not want to have an adjournment. So if you think he's reasonable in his suggestion that this is going to trigger a delay in the trial, then you better pull your horns in right now, because I do not want to adjourn the trial or delay the trial any longer. And if necessary, I'll strike the evidence if that's what could have been the expected result.
Your Honor, I would point one thing out to the court. These recordings that we have obtained are no less available to defense counsel than they were to us. He could have asked for these conversations if he'd wanted to. It's a matter of public record. And then any member of the news media can walk into the Kenosha County Jail and say, I want the recordings of this particular inmate from this date onward. And they will produce it.
At least the prison system will not do that.
Well, I'm not talking about, we're talking about the Kenosha County Jail.
And so will the Walworth County Jail. And I happen to deal with open records all the time, Your Honor. It's a public record, and explain to me how it's not a public record.
I could go in there and get all of the prisoners' comments about my rulings.
You could, and you know, Judge, you'd probably be proud of the things they're saying about you, as I am proud of things they're saying about me. But and there's, you know, he's making it sound like, oh, well, this is something we've been hanging on to and keeping it secret from him. The only limitation is how much of this stuff I can endure listening to. And he can go in, because Mr. Jensen probably spends several hours on the phone. I mean, tens of hours on the phone.
Of anything, and he's sitting in jail for a crime he didn't commit.
No, I think.
And here's the other thing.
I can't do it.
Well, then take down what I say. All right.
This is 97123, so everything he has to say about that, I should have gotten this. I don't have any obligation to do anything until I get noticed they're using my client's statements.
It says plans to use.
And there's an obligation. Well, he obviously was planning to use this. If it didn't go, he can't assume he's going to get whatever answer he thinks he's going to get from people.
Well,
and he didn't expect to get that answer.
I've already admonished him about that, and I told him I don't want this to happen again. And I've stated that I think you have had access to a large array. Access to and apparently listened to a large number of these phone calls. So if there's a thread about whether or not this is the way he talks to people, and you want to run the risk that the jury will just decide that he's controlling about it, you're welcome to do it. But I'm not going to presuppose that there's going to be a delay in the trial. In fact, I'm going to presuppose just the opposite.
Well, and Judge, I don't waste my time listening to a lot of phone calls unless I have notice as to what I'm going to do with them, because I can't introduce the calls as substantive evidence.
All right, I'm sure the Court of Appeals has an adequate record of what's the issue here, and I think the discussion is now fruitless. To go further, I'm going to permit the part you originally wished to offer, because the other parts would need substantial editing.
Okay, so from, I think it was about 9 minutes to about, was it?
It was 9:26 to 10:45.
Okay, so we'll say from 9:20 to 10:40? Just
the part that was originally played.
Okay.
And you can check with the reporter, because she took it down for the Court of Appeals.
And Your Honor, now there's a second CD. So we want to play that.
Second CD.
There's another conversation, and we're going to play another excerpt.
Just a lot of work yet this week to get it all yanked together. So, other question is what he should be getting out of you when he questions you. He is going to put you out there and have you read the emails, and that's the opportunity to have, forget about it all. But I know that doesn't always come across. Who's going to get it all? Get it all.
Okay,
I'll turn the sound down.
it's paused.
Yeah, but turn the sound down so that there was distortion and
sorry.
feedback from the microphone. That's, I think, what the problem was. Maybe you should move the microphone away from the CD player.
Move the microphone.
Oh.
Okay.
Go nuts, turn it on.
All right. Let me just say, I forgot to say this. This is a call September 29th, 2007, between Mr. Jensen and Mrs. Jensen, starting at 5 minutes and 45 seconds into the call.
Yeah, together. So, other question is what he should be getting out of you when he questions you.
Turn it down more.
He is going to put you out there and have you read the emails, and that's the opportunity to have, what we want to do with it.
Okay.
So I guess in terms of homework project, you got to come up with some answers, and I'm going to do the same thing. Maybe it'd be worthwhile. Think about it. We can compare notes, and then I'll give it to him.
What to
Guys, I have managed to get through 2 months.
Okay.
All right, did you want to say anything on this?
Yeah, there's absolutely nothing wrong with him following his lawyer's instructions to try to give me some responses to obvious questions that are here, or to confer with his wife and try to remember events of 9 years ago. There's no prohibition or anything wrong with that. And again,
Right.
I think 90403. I think this goes. It's unfairly prejudicial. It's a waste of time. It's likely to can cause confusion among the jury, and it has minimal or no probative value.
I agree with you that there's no prohibition against just discussing, witnesses' testimony with them in a non-threatening or aggressive or unlawful way, but that doesn't mean the jury can't consider the fact that he's doing that. And if you want a special instruction that there's nothing unlawful about it, I will give it.
I would. I also think these tapes are sort of unnecessary in the sense if Mrs. Jensen could simply be asked, did you ever talk to your husband about your testimony? But
well,
But I would like an
well, I think that this was all
instruction.
triggered by a question that the district attorney felt was not totally frank about a conversation, wasn't it?
Yeah, but they have no evidence to the contrary.
That's for the jury to decide.
That's what the CDs are for,
That's
Your
what the
Honor.
jury is to decide. So I would say that if you want to quickly prepare a special instruction about the propriety of an accused defendant speaking with a witness and engaging in a proper discussion about
Well, Your Honor, I would
tactics.
oppose to a special instruction unless I get to put some language in there about there's nothing wrong with a defendant getting his story straight before his wife testifies, because that's what they were doing. They were getting their story straight. And so what kind of a special instruction are you going to give to the jury that it's okay for the witnesses to collaborate among themselves so they get their story straight before they come into court?
You want to put that in a less biased way? We'll add it to what he prepares.
Okay.
So that
The instruction should be because to prevent them from jumping to some conclusion. There's often an instruction given that it's appropriate for both sides to interview witnesses, for example. And there's no addition to that to say that, to add the suggestion that, but if there's some foul play, then you can consider that. It just says it's not improper for either side to interview witnesses. It doesn't go into...
Well, this is, to the extent of interviewing is one thing, and coaxing a witness to testify in a certain way is another.
And comparing your notes, which is what was...
We're arguing about something that hasn't been suggested to the court yet. What I suggest is you each write out what you think would be an appropriate instruction and present it in, let's say, 3 minutes. And then we'll haggle about it when we've got something concrete to work with.
Okay, Your Honor, and the prognosis is not promising that we're going to come up with something that bears any resemblance to each other, and so the court's going to have to make a decision.
Well, if you're reasonable, you will.
Okay. I think he's going to find mine more objective, but we could see. Your Honor, here's
Who are you talking to?
here's my submission. What? Who?
Who are you talking
I was talking to you.
And presented previous conversations between the defendant and his current wife, Kelly Jensen. There is no law prohibiting conversations between an accused and his spouse or any other witness relating to the subject matter of this trial. You and you alone should consider the purpose or objective to be served by the conversation.
That's the state's submission, Your Honor. Which I think is remarkably neutral.
Well, let's hear Mr. Albies and see how...
I'm trying to make it legible for you, but here, I'll read it first and I'll continue writing it if the court would like to see it. There is nothing improper about a defendant talking with witnesses about past events or about their prospective testimony for the purpose of investigation or to help refresh either the defendant's or the witness's recollection. It is for you to decide what the defendant's purpose was in talking with any other witness in this case.
And Your Honor, my objection to that proposed instruction is that he's giving examples of proper reasons for conversations. And if he's going to give examples of proper reasons and he wants you to read this to the jury, then I think in fairness, you should give examples of improper reasons, because that's what I'm going to be arguing.
Let me have a look at yours in writing and so I can have the advantages of two senses reviewing it. Okay, how about this one? There is nothing impermissible about the state or the defendant discussing historical facts or potential testimony with any prospective witness so long as no effort is made to guide the witness to give false evidence.
That would be fine with me, Your Honor.
Could you say the first part again?
There is nothing impermissible about the state or the defendant discussing historical facts or potential testimony with any prospective witness so long as no effort is made to guide a witness to give false evidence.
Well, I don't think the jury needs an instruction on the latter part of that sentence because they know that. I mean, I think that I do think this is an appropriate place for an instruction to prohibit prejudicial inferences because they may, and I think the court's instruction, the beginning part, does that in the sense that they need to be told that there's nothing wrong with Mr. Jensen talking with witnesses about events. So I think that part is appropriate, but I don't think the instruction in a sense, I think sort of suggests that this may be inappropriate here, and I don't think it is.
Well, I don't share your concern, at least not to any great extent. You know what? I like mine better. So that's the way we're going to go. So I will give that instruction if and when the recordings are played. Or testimony is given respecting.
So there's one other option available, possibly, and I don't know if counsel wants to pursue that or not. The one option is that there be no instruction given. And my understanding is that that's the instruction you're going to give if an instruction is to be given, correct?
I'm going to give an instruction. That is going to be it.
Okay.
If the interviews are played, the jail tapes, CDs.
We intend to play them.
Okay, are we ready?
Yes.
Ask the jurors to come in, please.